Welcome to Wilmic's Risk Management Information Podcasts. I'm Tom Watson. In this podcast, we will talk about pro se parties and how lawyers deal with them. I'm speaking with attorney Paul Angel of Angel & Angel Law Firm in Dodgeville. Paul practices primarily family law, general litigation, real estate, and collection work. Paul, the struggling economy has impacted the practice of law in many ways, of course. One of those would be in the rise in pro se parties. I've seen estimates throughout Wisconsin that say as many as 80% of divorces in the state involve at least one unrepresented litigant. Are you seeing more pro se parties in your practice?
We are seeing quite a bit of pro se work. A good part of my practice is family law. And in family law, in the area I practice, southwest Wisconsin, there are large numbers. In cases, there's many situations where there's both sides are pro se. And then, of course, there's the cases where a lawyer's involved and the other party is pro se. And those are the ones, of course, I see. I don't see the others.
When you see a pro se party on the other side, how does it affect the way you have to handle a case?
All right. When I start out a case with a pro se party, I try to start it just as I would dealing with another lawyer. You try to be respectful, civil. I usually start out with a letter to them saying that I represent your spouse, that if they have a lawyer, let me know as soon as possible. The typical letter that you would send out, but that I will be trying to work with them to resolve the case. But I can't represent them. Anything I do would be for their spouse. So I try to draw that line clearly with them that I'm not going to be giving them any advice or helping them in any way, because sometimes that does happen where the pro se party starts trying to get you to do some things or starts asking questions.
And that brings up an interesting point, and that is how a lawyer can easily fall into that trap of sort of dual representation, which I think you're alluding to, where you end up almost unwittingly providing some legal advice to the other side, which, of course, your client probably isn't too thrilled about, but it also sets you up for the possibility of a malpractice claim or something like that. And as you say, you're drawing a clear line.
So I try to draw a clear line. Where the problems develop generally is when you start trying to have settlement conferences. I think in most family law cases, if you have cooperative legal counsel, most of us end up having a settlement meeting or one or more, trying to get the matter resolved. But when you have pro se litigants, that becomes a problem. When you start meeting with the pro se party, the spouse you represent, and sometimes those are difficult issues anyway, coming together. So what I try to do more often when I have a pro se party on the other side is to do a little bit more arm's length, where I maybe do it in writing. I may try to send out settlement documents like a marital settlement agreement, and just send it to them, send it in the mail. I think that settlement conferences can be sort of a problem.
You think that scenario is where lawyers tend to sort of fall into that trap of helping the other side?
Yeah, I think so. I've had a few situations where, for example, you pick up as a client, formerly a pro se party, and some have talked about their experiences. This is maybe primarily in custody areas where they were pro se for a while, and they were constantly dealing with the other lawyer, and they spent lots and lots of time. And they sometimes, I think that can be a big problem for the lawyer who's spending all the time with a pro se party. Many times they're just dragging the case on and driving up the costs.
Speaking of driving up the costs, that I think is another danger, isn't it? Where you've got this pro se party on the other side. They are either intentionally or unintentionally dragging the case out. You find yourself in a situation where you are spending more and more time on this case. Consequently, you're billing your client more. How do you deal with that?
Well, I think, Tom, that's a problem, and it's a good one to talk about, because I don't know about statewide, but in our area, many of the legal documents seem to be by custom prepared by the attorney who starts the case, the petitioner. What happens sometimes is you get into a case where you're representing the respondent, and so your client, if you want the case to move along, you've got the petitioner pro se, and so you start doing stuff. You start preparing documents, getting appraisals done. Maybe you have no cooperation, and pretty soon you're doing all the work. And so what used to be shared with the other lawyer is now passed on to your client. And I think that becomes a big problem of how do you allocate work when the other side can't do the work.
So how do you deal with that?
Well, you either you have a conversation with your client and you say, look, this is a problem. And either you want the case to move along, do you want it to get finished? And if you do, we're probably going to have to do more work than we normally would do if your spouse had a lawyer. It's going to be harder. It also, you get into one other, so I have that conversation with the client to explain that sometimes pro se cases can be more difficult, expensive.
Do you then find sometimes your clients are thinking, or maybe even they're saying to you out loud, the fact that I got an attorney, is going to cost me money, whereas my soon-to-be ex-spouse is getting off scot-free?
Absolutely, and I think oftentimes clients really don't like that, and it becomes a problem. I think all you can do though is to be direct with them and say, look, this is the way it's going to be. You can pretty quickly find out, get a sense of, is the pro se party, are they going to be cooperative? Are they going to try to work toward a solution? Or are they just, going to be, well, I see a couple different outcomes. Either they're going to be cooperative and you can make some progress, and maybe that problem of doing more work is minimal. Or you're going to, on the other hand, what I've seen, Tom, lately have been some cases, again, often in the custody area, where the pro se party is using internet information, sending out interrogatories, demands to admit, and actually making things very difficult and not costing anything and driving up the cost. Or they are the other thing I see is pro se litigants who are sort of fearful. I mean, they don't know what they're doing. If you send them something to look at in terms of an agreement to finish the case, they don't know. They don't know if this is fair or not. And so it's sometimes very hard to make progress. Either in either one of those kind of situations, neither one is willing to commit to a fair resolution. There's no one to tell them, their own lawyer that is, that this is fair. So then what do? Do you have a meeting where let's see if we have a meeting, and if you have a meeting with those kind of folks, either the ones who are fearful or the ones who are very aggressive, you're probably going to have difficulty keeping that line of, they start saying, is this a fair agreement, or what does this mean? And so I think that's where you start having problems.
I was at a family law conference not too long ago, and they were having this very discussion, and the issue came up of whether or not any of them in the audience felt comfortable asking the pro se party to contribute to your fees, and whether you should ask the court to ask or order the pro se party to contribute to fees. And there was some back and forth discussion. What are your thoughts on that?
My thoughts are that I don't see courts ordering attorneys' fees being a contribution toward attorneys' fees. It's pretty rare. And I think you're going to have problems with that in a pro se case. I think courts are probably not going to order it. It would take an extreme case for courts to order a contribution.
You mentioned sending the other party maybe an MSA, a marital settlement agreement, or documents of that nature, and they're not sure what to do with it and so forth. Along those lines, and maybe when an unrepresented party tries to file a motion, or they do something like that, they don't draft the appropriate motion, or they're late in getting something filed. Are you in a quandary as to whether you make sure they help them get it filed correctly to move the case along? In that respect, you're providing legal services to them, or do you let them just stumble around and how do you do that?
Well, what you see is a whole variety of things with pro se litigants, not just in family law, but you'll see pro se litigants, particularly who are defendants or respondents, writing to the court with complaints. They're quick. And again, talking about, I'm not sure what percentage this is. I mean, most pro se people are just like most lawyers. They're good people. They're trying to get through it. It's stressful, but The ones I'm talking about are, there's a significant minority of people who are going to be difficult to deal with, and they don't know what they're doing. So I'm seeing that I have to check CCAP to see if they're sending things to the court and not copying me in. I mean, they don't know the protocol. Or they're late, and then what do you do? Or they don't do anything. They don't file financial information. It's a whole different situation dealing with pro se litigants.
Do you find judges are more sympathetic to them?
I think, this is based on, I guess, in the last 3 or 4 years, 3 or 4 custody cases where I've been involved with pro se parties. I think courts struggle with how to deal with them as well. They don't know how to ask questions appropriately. They sometimes act inappropriately. I mean, they don't know what they're doing. They're not used to the system. And I think courts tend to occasionally interject with some comments and try to do it this way or that way. But I do think that courts have a difficult time when there's a lawyer on one side and a pro se on the other, of trying to maintain that appearance of being fair and impartial. It's a hard role when you're dealing with someone that doesn't know what they're doing.
Have you seen situations where you notice that the court is, in an effort to move the case along, they maybe grant some leeway to the...
There's some leeway given in some situations to the pro se party. I think they get a few breaks here and there. I mean, I think courts can come down harder on lawyers because lawyers are expected to know what they're doing. And if you're, I think what judges try to do is get through it. I have no idea what judges do when both sides are pro se. I think it's really it's put a bigger burden on courts. But particularly if you have a contested custody case, I think it becomes a difficult process when one party is pro se. And actually, some muddle through pretty well. When you think about it, they call some witnesses and they get through it. But I think in terms of some of the real technical requirements, I think where a lawyer might get called on it and told you haven't done this right, we're going to issue some kind of sanction. I think that pro se parties may get a break now and then.
Do you see this trend changing at all as we move forward, or will we continue to see a rise in pro se parties, or at least maintaining that level of pro se?
I think we're going to see more pro se parties. I'm seeing more people who there are people that can afford a lawyer that don't hire lawyers. I think part of it's driven by the cost of legal representation. Some people with their access, with the internet, finding materials, will just say, I can do it myself. And I think we're going to be dealing more and more with pro se litigants on the other side.
But does this trend mean the role of lawyers in the practice of law is going to change, or already has changed?
I think what lawyers are going to have to do is acknowledge that you're going to be dealing with pro se litigants and sort of develop a strategy of how you can most effectively deal with it. Lawyers are certainly capable of sizing up their opponent pretty quickly, whether it's the other lawyer or if it's a pro se. And if you're dealing with just good people who are at a stressful time, you're going to get through it. Okay, you're going to be able to work cooperatively. But what I've kind of decided to do myself is, if I size up the situation with a pro se litigant as being a party who's going to be difficult, who is going to be trying to delay or be unreasonable, I just try to set it up for a trial. And that's how we always finish cases, with trials. And otherwise, those cases languish. And I think you owe it to your client to say, look, this is going to be a little harder because we don't have anybody doing some of the work, or we don't have a lawyer saying to their client, you have to do this. You don't have anybody really helping the other party. You're going to get a little of that from courts if you have a motion, to require them to do something. A court may say you've got to do this, but essentially, I think what you're going to have to do with pro se litigants, if it's an important matter, as many of our, I'm talking about a $500 small claims case, but if you're dealing with a significant matter, I think you just have to eventually get the matter set up for a trial.
With the, we see self-help clinics now in courthouses and all over the country. So that, along with the things you've just talked about, I guess finally I ask you, what's your crystal ball vision of the future for the legal profession and for lawyers? What role will lawyers have in the practice of law in some areas of practice, like family law, in the next 10 or 15 years? Is it going to be a different world that we see in the legal profession?
I think it's going to be, for family law, I think lawyers will probably be doing fewer cases because I think that or lawyers are going to have to adjust their fees. I think that the fees of lawyers as a proportion of in terms of the proportionality of legal fees versus the income of clients is definitely changing. I think incomes of clients look statewide, are probably not going up, whereas legal fees have been. And I think that we have this separation now, which makes it, I think we're looking at a smaller market of people that can afford our services.
I think that bodes well for the solo practitioner or the small 2 or 3 lawyer firm that maybe doesn't have the overhead a bigger firm has?
I think that what lawyers are going to have to do, I'm talking mainly of smaller firms at this point, is to try to find more efficient ways of keeping your fees down and doing things more efficiently than we have in the past. But on the other hand, what I have seen happen, Tom, has been that their litigation, particularly in custody-related matters, is becoming more expensive. It's not getting simpler, it's getting harder. And so you've got these two different trends, and I don't know where it's going. I am seeing more pro se litigants just doing their own custody cases. And can you afford to do it for a client and spend a lot of money representing your client, and the other side is sort of just participating, but without fees? It's tough.
Thank you, Paul.
Yeah, you're welcome.
You've been listening to a Risk Management Information Podcast, a service of Wisconsin Lawyers Mutual Insurance Company. For more information about our company, visit www.wilmic.com or call 1-800-373-3839.